Hey guys, it's Gary, and I'm back with a legal tip. Today's legal tip unfortunately involves COVID. So the question is, what happens when a seller tests positive for COVID? What do you have to do? So this is something I think we need to go look at the actual statute and see what our statute says, because that really controls and governs our action. So in the statute, it says a material or adverse fact means a condition or occurrence that generally is recognized as presenting a significant health risk to the occupants of the real estate. Now, the CDC goes back and forth on this. At first, they told us if you touched a surface, you could get COVID. Then they changed their mind and said you can, and now they're back and forth. So I don't know whether touching a surface or being in a house where someone has been exposed is or is not. But I think generally in this community or in any community, they recognize it of being anywhere near COVID as a significant health risk. So that's our first thing we have to look at. The second thing we have to look at in the statute, it says we also have a duty to disclose to buyer all material adverse facts concerning the transaction, which are actually known to the licensee except otherwise directed in this section. So you do have a duty under this statute to disclose adverse material facts. We know that an adverse material fact clearly includes things that affect someone's health. Now, we have to also weigh that against the duty of confidentiality that we have with our client. And then in some ways, even though you're not a healthcare professional, you kind of start having to think about HIPAA and how these healthcare things come into being, and whether you need to be disclosing confidential information about your client. So they're kind of competing, and we have no guidance whatsoever. NARS has done the best they can giving us some guidance. What I would tell you is, first of all, follow whatever your company policy is. I am not here to set your company policy. If your company has a written policy, then follow it to the letter to keep yourself and your company from having any liability. So that's the first thing you do, is follow your company policy. Absent a company policy, I believe the first thing you do is pick up the phone and call the seller when they've notified you that they have tested positive, and ask for their permission and get it in writing to let the buyer know that they may have been exposed to COVID. But make sure you get that in writing from the seller. If the seller agrees that yes, you need to let them know that it's fine to let them know, then you need to contact the agent and let them know that unfortunately that your seller has tested positive for COVID, that you have been in the house within a certain number of days of that seller, and we wanted to let you know that you might want to get tested or quarantined or take safety precautions. Now, if your seller says, no, I don't want you to disclose it, I think at that point you have to tell your seller that you do have a duty to disclose a material adverse fact. And then obviously that would be one. So what they would have to do, I think what you would have to do at that point is notify the agent without specific details. I think what you would have to say is, I just need to let you know that you may have been exposed to the house, or been exposed to an area where somebody had COVID in it, and that you might want to get tested. If they ask you for more details, say, unfortunately, I'm not allowed to give you more details. I just wanted to let you know in the last 1 day, 2 days, 3 days, that you may have been in an area where someone has tested positive for COVID. Obviously, the person is going to know exactly what you're talking about, but you have not provided confidential information. So I would absolutely make sure that somehow that is disclosed in one of those two manners. The other thing I would tell you is, at that point, I think you need to advise your seller that you need to withdraw the listing from MLS for 14 days. What you can do is go to MLS, have a withhold from active listing form. I can't remember the exact name, but it's something of that nature where you can actually withhold the listing. Or you can go in MLS and just put no showings for 2 weeks, something of that nature. But I would not let anybody else inside that property for that 2 week period. So hopefully that will give you all some guidance. I'm sure y'all will have other questions. If you do, you can hit the button down there with the reply and just ask the questions to me, and I might have to do another video on this, but it's a very fluid thing, and we're trying our best to let you know what's going on. So hope everybody has a great weekend.